because you will hear it from my phone too. Um, Hi, everybody. My name's Angie Clark. I'm an attorney here in Lenoir, and the biggest part of my practice now is elder law and estate planning and probate work. And I really appreciate the Senior Center giving me this opportunity to share this presentation. I've been doing presentations for them for a couple of years now, and I always enjoy getting to meet folks that way and being able to share the information that hopefully is going to be important and relevant to you. And as April said, if you do have questions, you can stop me and ask those questions. I'd really prefer if you not get too specific about your situation, because everybody's situation is different. If it's a general question, that's fine. If you have really specific questions about your situation, it's probably good to have a consult with me or some other estate planning attorney to help you out with that. And then I'll also have some time, hopefully, I tend to talk too much, some time for questions at the end. But today's topic is based on a question that I often get from seniors, which is, should I transfer my home to my children before my death? And oftentimes seniors, when I talk to them, they've heard bits and pieces of information from others, and they come in thinking they know what they want, but they're sometimes confused and really don't have a good understanding of what options are available and what the consequences are. And a lot of times, hearing from friends and family and neighbors, sometimes they're a little bit misinformed about things. So I try to, basically what I'm doing now is what I do with a lot of my clients, is just giving a lot of the options. But as I mentioned, there really is not one single best choice for everyone, due to everybody having different situations, different families, and so forth. But everybody really needs to understand what the pros and cons are to be able to make transferring property, to be able to make an informed decision. So one of the first things that I do when I meet with a client and they want to discuss transferring a deed is I ask them, what are your goals? What is it you're trying to accomplish, so that I can offer them the options to try to best fit what they're looking for. And so before we start talking about actually transferring property, I did want to highlight or hit on a little bit of what happens to your real property after death if you decide you don't want to transfer it during your lifetime. And that is an option too. There's no requirement to transfer your property out of your name, but you should know what happens to it after your death. Now, keep in mind that in our discussion today, I'm going to be limiting the discussion to real property. That means your house. It can also mean empty tracts of land. It can mean other rental properties or commercial buildings, even for that matter, if they are in your name. So we're just talking about structures and land. We're not talking about personal property, because the ramifications to personal property sometimes, a lot of times, actually is different than real property. And so try to focus on that. But so if you are married and you own property together with your spouse, and it's in both of your names as spouses on the deed, and both of you are still alive, so what will happen if you don't take any action with your deed is you own that property. The terminology is called tenants by the entireties. I know that's strange and it doesn't make a lot of sense, but basically it's a special type of tenancy designed just for married people. And instead of owning the property as two single individuals, you own it as a joint ownership, as a unit, as a married couple unit. So you consider yourself as one when you're talking about married folks owning property. And so what happens is, if one of the spouses dies, or when the first spouse dies, that property is automatically owned by the surviving spouse by operation of law. There is nothing that has to be done. It's automatic at death. And there's even this is something else that folks are a lot of times confused about. There's really no need to have a new deed drafted for the surviving spouse. Even though the deed still has the deceased spouse name, it doesn't matter. You don't have to have the new deed. It still belongs to the surviving spouse. Now, since the property passes at the death of the first spouse directly to the other, that means that the property is not subject to the debts of the decedent, other than the mortgage, of course, which is attached directly to the house. But if there are doctor bills or credit card bills or things like that are owed, that are the decedent's, the decedent means the dead person, that if there are bills that are owed, they cannot be collected on by forcing a sale of that home. It's protected to the surviving spouse. And as another piece of information, if the surviving spouse later decides they want to sell that property, then it would be the same income tax consequences as if it were sold when the other spouse was still alive. And we're going to get into more detail about what kind of income tax consequences are there for selling properties as we move through it. So just keep that in mind. There's the same income tax consequences for a surviving spouse as it would be if the other spouse were still alive. So moving on now we're going to talk about what happens to a piece of property at the death of the owner if the property was owned only by one person, a sole owner at death. And this includes that surviving spouse who inherited directly from the deceased spouse, and now they are the sole owner of the property. So what happens now when that sole owner dies? Well, first of all, it depends on whether or not that owner, the decedent, had a will. If the decedent had a will, then the court will look to see who is named in the will to inherit that real property. And if there is someone named, or a collective group like to my children, then the property will pass directly to those heirs that are listed in the will. If there is no will at the sole owner's death, then the property will pass under the laws of intestate succession. That's a fancy way of saying there's no will, and North Carolina provides laws that dictate how property will pass at death in the event of no will. And as far as real property is concerned, if there is no will, they're going to look to see if the decedent, the sole owner of the property, had a spouse. Now, remember I said your spouse died, but you may have remarried, but never added your new spouse to the deed. So that means you're still the sole owner. Or we could just be talking about a situation where there was no spouse at all to start with, and now we've got a single owner. So the first thing the law is going to do is look to see if there's a spouse and look to see if there's children. If there is a spouse and no children, then the property will pass to the surviving spouse. If there are children, or if there are grandchildren of predeceased children, the statute refers to that as issue, then the property is going to be passed to the spouse and to the children, or potentially grandchildren. And it depends on how many children there are. It gets really a little complicated here to determine what percentage ownership of that property goes to the spouse and what percentage goes to the children. So I'm not going to try to get into the individual details of that, but just know that if there is a surviving spouse and children, they're going to own it jointly in some percentage. If there is no spouse or no children at all, then of course the statute provides that we're going to look to see if there's grandchildren or maybe great grandchildren, if we're depending on the age of the decedent. If there's no spouse, there's no children, there's no grandchildren, the statute says, are there surviving parents? And in the case of most older folks, seniors, we're not going to be talking about any surviving parents either. So then we're going to look to see, did the decedent have any siblings? The property will pass to them. If there are no siblings, or if there's a deceased sibling, we're going to look at nieces and nephews. And so you can see that we're going to start branching out on the family tree when we're potentially talking about intestate succession. And you can end up with quite a few heirs to a piece of property this way, which usually doesn't work out very well. When you end up with multiple heirs owning one piece of property, it starts causing problems. Just to give you an example, I had an estate not too long ago where I ended up with 32 intestate heirs. 16 were nieces and nephews, and 16 were great nieces and nephews, and it created quite a mess that we had to work through. Okay, if you have the sole owner that dies without transferring the property, regardless of whether there is a will or not a will, if that decedent had debts at their death, then the house may have to be sold by the administrator or the executor of the estate. It may be required that that house be sold to pay those debts. And this happens frequently if the decedent has been in a nursing home and has had to rely on Medicaid to help pay for their nursing home care. Medicaid will file a claim against the decedent's estate at death and ask to be paid back for any cost that they paid for the nursing home care. And this happens more often than you would think. And unfortunately, this is where a lot of people end up working their whole lives to build this home and hoping to pass it down to their children. And then the property has to be sold and there's really nothing left to pass down to their children. Also, just a point to note that if the property does have to be sold to create assets to pay these debts, this will also increase the amount of fees that end up having to be paid to the clerk of court as part of the administration costs. So if the house doesn't have to be sold, there's no extra fees as far as the estate administration. But if the house has to be sold, then you're going to talk about more fees too. So it ends up creating less assets to go to the heirs, essentially. As far as if there is no debts and the house passes directly through the will or directly through intestate succession to one or more heirs or children, there is no new deed. There's no requirement to have a new deed drafted. Again, just like I talked about with the surviving spouse, when this property passes, for example, this is not accurate about my situation, but if my parents died and my brother and I inherited the property and we decided not to sell it and we wanted to keep it, we don't have to have a new deed drafted to say that it belongs to me and my brother. It's automatic because my parents had a will and it names us as their heirs, and so we would own it and we could do whatever we wanted to with it. We would not have to have a new deed drafted unless we wanted to sell it, or unless we wanted, like my brother wanted to transfer his share to me or something like that. If there's a sale or a transfer, that's when a new deed is required. This is something that a lot of people are confused about and think that, oh, we have to have a new deed drafted. You don't. So if the sole owner dies and the heirs inherit the real property and then they decide to sell that real property. So say my parents died, I inherited their house, but I have my own house, I don't need it. So my brother and I decide we want to sell it. If we sell the property, we do get a favored income tax ramification as a result of what is called stepped up basis. And I'm going to kind of take a detour here to explain to you what that means, because a lot of people don't understand what basis is and how it affects property on a sale. So here we're talking tax law, and I know I'm a tax nerd. So for those of you that aren't, I'm sorry, I'll try to break this down and make it simple. But when we're talking basis, that's a tax term. And what it means is, in its most simplest terms, is what did you pay for the property? What is your basis in the property? Means what do you have in the property in terms of money? So just to give you an example, let's say that we'll use my parents' home again. Let's say that my parents bought their home a long, long time ago and they paid $50,000 for the home. Their basis, therefore, is $50,000. That's what they paid for it. Now, a little bit complicated here. If you add capital value to your home, in other words, if you add an addition or a room, or you make capital improvements and you screen in the porch or something along that line, that can actually increase your basis because you're adding money into the home itself and you're bringing up the value. So, but just to try to keep it simple, my parents paid $50,000 for their home, and when they die, the statute currently, and of course tax laws are always subject to change, although I don't see this one being changed. It would not be very popular with constituents if the legislators wanted to change this. But currently the tax law says that when a person dies and they own property, the heirs received what's called stepped up basis. And that means at the moment of death, the basis goes from $50,000 for what they paid for it. Now the new basis for the new owner, the heir, is now whatever the fair market value of that home is at the date of death. So in my scenario, let's say my parents bought the property for $50,000, but when they died, the property was worth $100,000. Well, my brother and I then would have a tax basis of $100,000. Even though we didn't pay the extra 50, we didn't put any money in it. We inherited it from our parents, and so we get that stepped up basis. Now, where does that come into play? Well, that comes into play when you go to sell it, because when you sell property, the gain that you receive from the original basis to what you sell it for, you may get taxed on that. It's capital gains tax. And there's some exceptions. If you live in the property for 2 out of the previous 5 years, you're exempt from that tax. But so in my example, my parents bought it for $50,000. They died. We inherited it. It was worth $100,000 at death. That's my stepped up basis in the property. And my brother and I decided to sell it. Well, if we sell it pretty soon after their death and we sell it for $100,000, then we look to see what our profit is. Well, we sold it for $100,000. Our basis was $100,000. Our profit is $0. Therefore, there's no capital gains tax. But let's say we didn't want to sell it right away because we wanted to hold on to it. We had made up our mind. So let's say a year after my parents' death, we decided to sell the property. And at that point, the property had increased in value and it was worth $150,000, which in today's market would not be unusual to have that property increase in value that quickly. But just as an example, we sell it for $150,000. Well, neither one of us lived in it during that year's period of time. We either had tenants or we just let it sit empty, and we sold it for $150,000. So our tax basis is $100,000. We sold it for $150,000. So our profit is $50,000, and that $50,000 now is subject to tax. We have to pay capital gains tax on that $50,000. And of course, we would split it. He would get $25,000 and I would get $25,000, but we would have to pay taxes on that. So I tell you that because as we go through these different types of deeds, I'm going to explain whether there's a good or bad tax ramification. And when I'm talking about that, I'm meaning capital gains tax, income tax. I'm not talking about property tax that you pay to the county. I'm talking about the income taxes. So back to what I was originally saying, if a sole owner dies and their heirs inherit the property, they receive that stepped up basis. And that's a good thing. That's a good thing. All right. The main reason why most folks that I deal with and talk to are considering transferring the property before death is because of that obligation to pay those debts. Remember, I just said that if I own that property at my death and I had debts at my death and there's not enough other assets in my estate to pay those, the court may require that they sell my house in order to pay those debts. And a lot of folks say, I don't want my house to be sold to pay my debts, especially if I've ended up in the nursing home and I've had to have Medicaid. To get Medicaid to even qualify, you're not going to have any assets or very little assets because you couldn't have to qualify for Medicaid. So that's where a lot of people end up having to sell their home to pay back that Medicaid debt. So they say, well, can we prevent that? Is there a way to protect my house so that my children can inherit that and not have to pay to sell it to pay back debts? And yes, the answer is yes, there are some ways that we can do that. And that's the main reason a lot of people are considering transferring deed to their children before death, is to avoid that debt collection part. So I'm going to highlight a couple of different options that there are to transfer your home. I'm saying home, it can be any real estate. It doesn't have to be your home, but I'm using home because that's what most of us are dealing with. But the most simple and direct type of transfer to put a deed in your child or children's name is just a straight out transfer. I'm going to give you my property. I'm going to take it out of my name and I'm going to put it into your name. That's it. I will tell you that I very rarely will recommend this type of straight direct transfer because of some negative implications that it can have, and I'm going to highlight those for you. There are some occasions when I sit down and talk with the client that this is actually what we do, but it's not my first choice for most people. And here's why. If you transfer your property out of your name and give it to your child or children and go ahead and put it straight in their names, then you actually have lost control, complete control of that property, and they can kick you out of your own house. It wouldn't be your house anymore. You would have given it to them. And I actually had this scenario happen one time. I advised a client against this type of transfer, and she wanted to transfer the property to a grandchild and have her name off of it completely. And I advised against it and explained to her why. And she said, "Oh no, my grandson would never kick me out of my house." Well, 6 months later, she's in my office crying. Grandson kicked her out of her house, and there was nothing I could do about it. And it broke my heart. But that's why I don't like that. So you lose control of the property that way. Of course, if you've given it away completely out of your name, then you don't own it at your death. So there's nothing to transfer at your death anyway. So we don't even worry about what happens at your death, because it's not even, you don't have any ownership in it. One thing, tax ramification wise, if you do transfer and gift this property to your child or children for no money, then the child takes the transfer basis. It's a gift basis. So whatever you paid for the property, now that's your child's basis too. They don't get that stepped up basis at your death. So in my previous example, if my parents had gifted that house to my brother and I during their lifetime, we would have had their basis of $50,000. We would not have received the stepped up basis. Therefore, if we then sold it, just keep the same scenario going, we had sold it for $150,000, then we would be looking at paying taxes on $100,000 worth of income instead of $50,000 tax of income. So it can make a significant difference tax-wise as well. And then finally, one other negative for transferring a straight out direct transfer to your children is if the original owner ends up needing nursing home care, and therefore Medicaid, typically that means having to get Medicaid to pay for that because it's so expensive. Within 5 years of that transfer, then there will be a penalty that Medicaid will put on you. And that penalty is that they are not going to pay for your nursing home care for during a specific period of time. And that is based on the value of the gift. So you may have heard of a Medicaid look back period. It used to be a long, long time ago that they look back 3 years to see what property you've given away or transferred, and they extended that. Now it's 5 years. So just know that if you make a gift, and this doesn't just have to be of real property, if you make a gift of money, if you say, "Hey, you know what, I have all this extra money in the bank and I want to, I'm thinking I might need some Medicaid, and I want my children to be able to inherit this money, so I'm going to go ahead and give it to them now, or I'm going to transfer it over and we're going to put it," I had this happen recently. Parents put the money in a bank account in the children's names, kept their names off of it, and the children were great children and they were very loyal to their parents, and they weren't spending the money, although they could have. They were keeping it for their parents. But that is looked at as a gift, and if there's Medicaid that's needed within 5 years of that gift, it will come back to bite you. I mean, there will be a penalty period there. So transferring property outright as a gift can be a little risky. Now, on the flip side, if you can transfer that property more than 5 years before you ever need Medicaid, then you're fine. That look back period is only 5 years. So if you can make that transfer and you don't have to worry about the 5 years, not a problem. I still don't like that kind of deed because of the control issue and the tax ramification issue, but it is a type of deed that can be done. I'm going to move on to one of the most common transfers that I do and other attorneys do to help protect that property, which is a transfer to the children, but the owner retains what's called a life estate. And I'm going to have to divert a little bit and give you a little background on what some terminology, because as we move forward, I'm going to use some terms that may be unfamiliar to you. So a life estate deed means that the owner now becomes what's called a life tenant. They do not have any ownership interest in the property, but they have a possessory interest, meaning they have retained the right to possess the property, to live in the property for their lifetime. Nobody can take that away from them, but they've lost the ownership of it. So they are called a life tenant. The ownership now goes to the presumably the children. It doesn't have to be a child, but that's the most common. Ownership now goes to the children, but the children are what are known during the life of their parents. They are known as the remainderment, meaning that their ownership interest doesn't come in full until their parent dies, because their parent has retained that life tenancy. The children can't sell that property. They can't kick their parent out of the property. They can't really do anything with the property because they don't have that possessory part of it. They have the ownership part, but they don't have the possessory part. So it's kind of tied up, which is a good thing because you don't want to get kicked out of your house. Now, at the death of the life tenant, so presumably you statistically will probably die before the children will. At your death, then the possessory portion of the tenancy is inherited by the children. And so they have now their ownership interest and they have their possessory interest. And so now they own the property completely. And it's all done by operation of law immediately upon death, meaning that there's nothing to file in the clerk's office. There's nothing to file at the register of deeds. There's no need to create a new deed. It is an automatic ownership at the life tenant's death. That protects the property from having to be sold to pay debts. So that is a way to protect that property, to make sure that it goes to the children, to make sure they can't kick you out of it. It is a very widely used type of deed because it has all those protection factors in there. But it doesn't come without its risks and its cons. So I want to make sure to point those out too, because so far I've made it sound perfect. And why would everybody not want to do this? Well, there's some risks. So one of the first risks that I want to talk about is typically a minimum risk, but it is a risk nonetheless that you need to know about. And that is, what happens if the child dies before the parent dies? What happens then? Well, in that case, that child's remainder interest will pass to that child's heirs, either through their will or through intestate succession. And so if, let's just use an example, let's say I did a life tenancy with my property and I made my daughter as the remainderment. And then my daughter died before me. Her share would then pass to her husband and children, depending on, again, her will or whether she had a will or not, but it could pass to her husband or her children. And so now I still have the right to live there. That none of that changes, but now I've got a different person that's going to inherit it at my death. And I might not like my son-in-law. I might not have wanted my son-in-law to have that. But I'm out of luck. I can't do anything about that at this point because my daughter willed it to her husband and I can't change that. So I actually had a client with a similar situation to this, really unfortunate. And again, it was one of those situations where she came in for help and I had to tell her, I'm sorry, there's really nothing I could do. She had done one of these deeds thinking that she was protecting her property. She had given the remainderment to her children. She had 2 children, and her son died unexpectedly, and his share passed to his wife. And then, of course, her daughter still had her portion of the remainder interest. Well, she decided she wanted to sell the property. You know, this property is too big for me. I want to sell it. I want to downsize. And that's the one of the negatives, or one of the potential cons of this type of deed, is the remainderman doesn't have any right to sell the property. The life tenant doesn't have any right to sell the property unless the children agree, unless the remainderman agree. And so this lady wanted to sell her property. Her daughter said, "Sure, Mom, I'll sign your deed. You know, I support you." The daughter-in-law, who inherited her son's share, said, "Not signing, not going to do it." And there was nothing, not a thing I could do to help this lady, as far as legally trying to make that happen. It wasn't going to happen. So that is a small risk, but it is a risk to keep in mind. As I just said, the life tenant cannot sell or mortgage the property, the entire property, without the consent of the remainderman and their spouses. In North Carolina, even if a deed does not contain the spouse's name, if it is going to be transferred through a sale or a gift, the spouse is going to have to sign off on that deed. And so sometimes if you have some family issues with in-laws and things like that, then this may be a red flag that you want to think about. As I said, at death, the positive part is it passes by operational law, so there can't be any forced selling of the house to pay back debts. But that Medicaid problem is still here with this type of deed, unfortunately. Typically, when folks do a life estate deed, they are giving the house to their children while they retain that life interest in it. That is considered a gift. And if you need Medicaid in the next 5 years, that gift is going to cause a penalty. Now, it can be undone, and I've done this a couple of times where they couldn't make the 5 year, they needed the Medicaid, and there was going to be a penalty. So the children agreed. We signed that property back over to the parent to get it back in the parent's name, so we undo the gift. But sometimes the children may not agree to do that. And so you are left with the potential, again, of having that Medicaid penalty, having a portion of your care not being paid for, and that can cause some problems if you can't pay your bill at the facility. So that is probably the biggest risk to this type of deed, is that 5 years. If you can make it past that 5 years, this is the absolute best type of transfer deed in most cases, if you can make it that 5 years. So I'm going to tell you about one last deed, and then I'm going to leave some time for questions. This is an alternative to that life estate deed that I just described. It has a lot of the same features, but it has some different features as well. This type of deed is called a joint tenant with right of survivorship deed. Joint tenant with right of survivorship. And unlike let's go back to my scenario when I said if my parents died without transferring the property, my brother and I would own it jointly. Well, we own it jointly as what's called tenants in common, meaning he owns 50% and I own 50%. And if I die, my 50% goes to my children. And if he dies, or my husband, whoever I leave it to, if he dies, his 50% goes to his heirs. And we own it jointly, but we don't have a survivorship clause in there, meaning we're separate. We have 50-50 ownership. There is another type, the joint with right of survivorship deed has joint owners, but there is a survivorship component to it. And a lot of you may already know about this in reference to like your bank accounts, your checking account. A lot of people own a joint checking account with right of survivorship. And that means when one person dies, the other person automatically owns that account. Same thing with real property. You can own that with joint with right of survivorship, so that when one person dies, the other joint owner automatically, by operation of law, owns the whole thing. And so a type of deed that I do quite frequently now, I call it a 99-1 deed. And that basically means that the primary owner of the property will retain a 99% interest in the property, while either selling or gifting a 1% interest to their child. And they hold the title to the deed as joint with right of survivorship. Now, this only became possible in North Carolina back in 2011, when the legislature passed a law that would allow joint tenants to own property in different percentages. Some states, for example, South Carolina, my understanding is that if you own property, joint tenants with right of survivorship, all the joint tenants have an equal share. But in North Carolina, you can differentiate that share. You can make it 50-50, you can make it 60-40, you can make it 85-15, or what I like to do is a 99-1. Why that? Why do I pick 99-1? Well, the reason why is if you deed your property, you deed 1% of your property to your child or your children while you retain 99%. Well, you have 99%. They can't kick you out of there. You are a majority owner. So you still have that protection from being displaced from your property because you own the majority of it. Now, I should have mentioned, and I forgot, when you have the life tenancy, the life estate deed, the life tenant is responsible for the insurance, the taxes, for the upkeep during their lifetime. They're responsible for those payments. In a 99-1 deed, the 99% owner is responsible for 99% of the taxes, the insurance, and the upkeep, and the 1% owner is legally responsible for 1% of those costs. Now, in reality, typically, especially if it's parents and children, the parent typically pays 100% of the taxes, and they don't ask their child to chip in that 1%, although legally they could. So again, neither party can sell or mortgage the property without the consent of the joint owner or spouses. So we've got that restriction in place as well. Again, at the death of one of the joint owners, the property does not become part of that decedent's estate. It does not come in and is not controlled by the clerk. It is not controlled by the will. It automatically passes to the joint owner. So that's a good thing. I mean, that's what you're looking for. You're trying to protect it from debts. The basis and the tax ramifications, a little bit, I forgot that too. Going back to the life estate, tax ramifications. So when the life tenant dies, the statute allows the positive tax ramifications and allows that stepped up basis for the remainderment. So it's a good thing. The heirs, the children still get that stepped up basis, which is going to reduce their tax burden if they choose to sell it. The 99-1 deed, the basis and the tax ramifications are very, very similar, but just a little bit more complicated because now we're talking about 99% of the basis is stepped up basis. The 1% is, depending on whether it was a gift, it would be the transfer basis, or if they bought it, it would be the basis they bought it for. So the basis is a little bit more complicated, but for all practical purposes, if 99% is stepped up, you're going to have positive tax implications from that. You're going to get the majority of it stepped up in basis. Medicaid, let's talk about how that impacts with Medicaid and needing to apply for Medicaid. So keep in mind, you're only transferring 1%. Even if you give that 1% as a gift, in other words, you don't make your child pay you for that 1%, then that amount of that gift is minimal. It is whatever 1% of the value of your property is. And in most cases, Medicaid is going to look at the tax value to determine that. And that's what we typically look at when I'm advising clients, is I take a look at what your tax value is. So let's go back to that $100,000 house. A $100,000 house, 1% is $1,000. So if I do a 99-1 deed and I gift 1% to my child, then that gift is the equivalent of $1,000 gift, not a $100,000 gift. So when I'm looking at Medicaid and I'm looking at a potential penalty, I've only got a gift of $1,000 and instead of 100,000. So we can typically manage that and handle that kind of penalty. If you want to avoid the penalty altogether, you have your child buy their 1% interest for whatever that 1% value is. Then it's not a gift at all. And then you have no penalty. And a lot of times, if I'm advising clients who it looks like nursing home care is pretty imminent, like very soon, I will advise for the children to buy that 1%. Don't just gift it, buy it, because you're going to avoid any penalty at all that way. And again, you can typically use what the tax value is to determine that 1% interest, and just make sure that the child writes a check to the mom or the dad for that 1%. Make sure they get deposited into the parent's checking account. There's a paper trail. So if Medicaid ever asks, you've got the paper trail to show exactly what happened. One of the risks, or a couple of the risks that I want to talk about, one is if you have multiple children and you want to do this deed with multiple children, what I typically do, for example, if there's 2 children, I'll give each child a 0.5% interest, so the parent still retains the 99%. And by the way, it can be a married couple can still do this too. The married couple can retain 99% between them, and the children can have 1%. So it doesn't have to just be a single person. It can be a married couple that can do this type of deed, and the life estate deed can be married couple as well. But on a joint tenancy with right of survivorship, remember I said, typically the parent's going to die first and then the children own it automatically. Well, if you have multiple children, they own it still as joint with right of survivorship. The type of deed doesn't change unless you change it, unless there's a new deed drafted. And so what that means is, so let's say I die and I have 2 children, and my 2 children now own my property, but they own it together as joint with right of survivorship. So if one of them dies, it automatically belongs to the other child, and that child that died, their children and their spouses get nothing. So that's a bit different than the outcome with the life estate deed. You've got that survivorship component to it, and it may or may not be what they want. But I just like to bring that to people's attention that have multiple children on the deed, that after the death of the parents, the children, unless they're planning on selling it pretty quickly, they may want to consider changing that type of deed from a joint with right of survivorship to just a regular tenants in common deed. The other implication is, what happens if the child dies first? Remember, I gave you the scenario with the life estate deed. If the remainderment child dies first, then their heirs will inherit their remainderment interest, and you as the life tenant owner can't do anything about that. Well, because it's a survivorship deed, the heir, if the 1% owner dies first, then you're back to owning 100% again, and you're back in the same boat you are before you ever made the transfer. So just to give you an example, I'm trying to protect my property from Medicaid, so I do a 99-1 deed to my daughter. My daughter dies first. Now I'm back to owning 100% again, and I'm back to where I started from. So if I want to continue to try to protect that property, I'm going to have to take another action. Now, if you have multiple children, like say I had a son and I do have a son and a daughter, and I do this 99-1 deed where I keep 99%. Each of my children have a 0.5% interest. My daughter dies before me. Now I own 99.25%, and my son owns 75.75% interest, 3/4 interest. So we absorb her 0.5% into both of us. And so he's still going to inherit my house if I die next. So you have to look at how many children you're talking about to figure out what happens if who dies first. The only other caution, I guess, I need to tell you about this 99-1 deed, because hey, it's sounding really, really good, right? It protects you against Medicaid. You don't have to worry about the penalty. It transfers at your death, all those positive things. The only other caution I would give about this deed, this type of deed, is that there is some concern among elder law attorneys that there is a possibility that the legislature may take some kind of action to void this kind of deed in the future, because it does keep Medicaid from getting their money back. And so there's just nothing's been put before legislature. This is a state law. Nothing has been put in front of the legislature. There's been no even grumbling about it in the legislature, but a group of elder law attorneys feel that, you know what, this is a prime target because the government may very well say, hey, we want to get our money back. We're going to void these kind of deeds. And if that happens, it could potentially be retroactive and void your deed. It hasn't happened since 2011. There's nothing on the horizon that tells me that it's going to happen. But of course, I'm not a fortune teller. So I can't predict exactly what's going to happen. So I just tell people this to say, hey, keep an eye out. I definitely, as an attorney, I keep track of who I do these deeds for. And obviously, if I see something like that coming or it passes, I am going to reach out and contact all of my clients that have this kind of deed to say, hey, we need to rethink what we're doing here. But is it a risk? Sure, everything's a risk, but there's nothing to suggest that it's going to be a risk that's going to affect anybody anytime soon. So what I've talked to you today, these are really just the basics for alternatives for your real property. There are other considerations that may need to be addressed, such as if your children have creditor problems or if your children have special needs and an inheritance would cause them to lose benefits or something like that. So there's obviously everybody's situation is different and there's all kinds of factors that play into this, and there's no way I could address everything. So what I would recommend is, if this is something that's interested you and you think, wow, this might be something I want to consider, I highly recommend that you meet with an attorney who is knowledgeable about the different kinds of deeds and the pros and cons, and sit down and talk about your specific situation to see which of any of these would be the best avenue for you to take. So I've hurried through it because I wanted to make sure to leave time for questions, and I apologize for talking so fast. I know I get carried away sometimes, but thankfully the senior center is recording this and you can rewatch it to pick up the points that maybe are a little confusing to you, but I'll be glad to answer any questions that anybody has right now.
I have a question.
Sure.
Okay, it goes to the last possibility you were speaking about, the joint tenant with right of survivorship. So I don't know if I understood correctly, but you were saying even if you saw that you were going to need nursing home care fairly soon, could you go ahead and put this in place even though it hadn't been 5 years?
Yes. And what I would recommend is that 1% that you are transferring to your children, you make them buy that from you at 1% of the value of the home. Then it's not a gift, it's a purchase, and there's no gift. And if you are going to do this, do it before you apply for Medicaid.
Absolutely. Yes. And so if you have multiple properties, do you have to go in and do it for each of these properties?
Yes.
You have your home and then you have other real estate and others.
Yes. There are some complications, especially when you're talking about Medicaid and you own more than one property. There can be some complications with that. But the short answer to your question is, any property that has a deed, if you're going to do some sort of transfer, yes, you have to do a separate deed for each property. Now, I have had clients that have had where they purchased their house and their home, and then later in time they were able to purchase the lot next door.
Yes.
That butts up to it. So they currently have 2 deeds. I will typically advise them when we're doing this transfer to put, since if they touch each other, if the properties are adjacent and they are contiguous, I will advise them for when they transfer the deed to put both tracts together on one deed. We can do that. We call them tract 1 and tract 2. And now they are together and they're treated as one, even though they are 2 different tracts. So I will typically advise that in that situation. But if we're talking about a home here and another rental house or something, down the road, we have to deal with 2 different deeds for that.
Okay, that is very helpful. I was not aware of this option that you just brought up, so thank you.
Mm-hmm. You're welcome.
Yes, I have a question.
Sure.
Yeah, you're talking about real property, houses, land, etc. In the gifting of a house to children in any of these scenarios, what about the personal property in the house? You know, the furniture, the stuff that's in the house. Does that go with the house or what?
No, it's treated separately because it is personal property unless you do some sort of document to that's your intent. The personal property does not pass automatically. So what I tell people is we need to address that usually in somebody's will. We'll put all my household goods are to go to whoever. But personal property is treated separately and it is not included.
So if you put a clause like that in your will about all the personal property going to the child or the children, or split to the children or something, is that easily probated when the will is processed by the clerk of court?
Typically, yes, especially if we're just talking household goods. That's usually really easy to do. If your personal property is more complicated, like you own businesses or you have,
I'm mainly talking about furnishings and things in the house.
that's fairly easy to do. And although that property is susceptible to be having to be sold to pay creditors,
Oh yeah.
Usually, for court purposes, when we value household goods and personal property, we use what I tell people are yard sale value. You know, it's not replacement value. It's not what the property costs new. It is typically what you could sell it for at a yard sale. And so for most people, the value that we assign to household goods is usually kind of minimal. And it's not to say your stuff isn't worth anything, but there's a fee that has to be paid to the clerk based on the value of your property. So for one thing, we're trying to minimize fees, but realistically speaking, if you were to, open your doors and have a yard sale, what would you make? And that's the value that we use, and it does pass pretty easily.
Okay, all right.
I have a question too about if you want your child to buy 1% and you do receive Medicaid, is there any funds there? Even if you go to a nursing home, you don't receive any Medicaid.
I'm sorry, I'm having a hard time hearing what you're saying. I know you're talking about something with the nursing home and Medicaid, but I didn't hear the question.
If you don't need Medicaid.
What if you don't need Medicaid?
Yes.
Oh, well, if you don't need Medicaid, then you don't have to worry about any of that stuff I talked about with the 5-year look back period. I only mention that because statistically speaking, about 60% of Americans are going to end up needing some sort of nursing home care, whether we like it or not. And most people don't have long-term care insurance. And you may or may not know, Medicare and your supplemental insurance are not going to pay for the majority of nursing home care. It may pay for some rehab period at the beginning, but if it's an extended period of care, Medicare is not going to pay. If you have long-term care insurance or you have enough assets that you can pay for your own care and you don't need Medicaid, then you don't have to worry about the gifting provisions and the 5-year look back. Your property will just pass either according to your will, or if you do one of these transfer deeds, it will pass automatically at your death and you don't have to worry about that issue.
I understand.
Okay, thank you.
Thank you.
You're welcome.
I have a question.
Yes, ma'am.
If the property is in joint, the property or a checking account or whatever is in a joint with the parent and the children, their names are on all that. Then if that money or property was used to pay for nursing home care, can the children take the money and because Medicare doesn't pay everything, Medicaid doesn't pay everything. Can the children take that money and, set it aside for use for the parent?
So if you're talking about money in a checking account and you're saying that it's jointly held by the parent and the child, then it's considered money that's available to pay for care. Yes, Medicaid is not going to, you're not going to qualify for Medicaid if that checking account is in excess of the limits. And for single people, that's $2,000. So if there's more than $2,000 in that checking account, it's all going to be considered assets available to pay for care. And you'll have to spend that on your care or other qualifying purchases, which
What I'm saying though is, can the children take withdraw their portion of that money?
there you're getting tricky, because to say it's their portion, they would have to prove that they put that money in there and that it didn't come from you. And that's where you're going to have to start tracing the funds, and that can get a bit complicated. So, you know, yes, maybe, depending on if they can trace the funds back to show that it wasn't the parents' money to start with.
Thank you.
Oh, you're welcome. Does anybody else have any questions?
I do have another question. Can you hear me?
Yes,
Okay,
ma'am.
and you may have covered this, but since you covered so much great information, I'm not sure. So let's say both spouses are living, one spouse needs nursing home care, and they have this home and property. Can one spouse qualify for Medicaid while the other spouse continues to have and live in the home and have property? Or
yes. So and I've done a Medicaid presentation before, and I cover this, and I'll probably try to do another one, but to try to keep the answer simple, because it can get complicated. When you're applying, whether you're married or single and you're applying for Medicaid, the primary residence is not considered a countable asset for determining qualification for Medicaid unless it's valued at over $500,000. And so, which for most of us, that's not the case. And so the house is not going to count. Yes, one spouse can qualify for Medicaid. There's some other complicated factors to that with other assets. But as far as the home's concerned, and then the spouse that doesn't need nursing home care can continue to live in that home. They're not going to take it away. There is some question now as to what happens when the Medicaid spouse dies, and Medicaid is going, the house still belongs to the surviving spouse, as I told you, but Medicaid is trying to change their policies right now to say they could put a lien against that house. So when the other spouse dies, they can collect. There's a group of lawyers that are filing lawsuits saying, no, you can't do that. That's not legal. So that's kind of all up in the air right now in terms of what happens when that second spouse dies, if you haven't had any other transfers in there. But the short answer to your question, yes, you can still qualify for Medicaid and have the house.
thank you. Very helpful.
I have
Sorry,
a question.
everything has to be so complicated, and there's so many factors that you have to think about, but that's just how it is.
Okay, I have a question.
Yes, ma'am.
If I should have my property put in, and my house put in my children's name, and I am here and I have to pay the taxes, in the event that I have my income is where I could get a tax break, can I still file for the tax break for property taxes?
That's a great question. I'm glad you asked that. So yes, a lot of seniors that are on limited income can have their property taxes reduced. There's a senior rate that you can do that. As long as you're doing the life estate deed or the 99-1 joint with right of survivorship deed, you can maintain that reduction in your property taxes. Okay. Yes.
Thank you.
Mm-hmm. All right. April, can you attach maybe to this recording, like my business card or my information about how people can reach me if they want to discuss their situation further?
Yeah, we'll do that. We sure will.
All right, I appreciate that.
Did anybody else have a question before she goes? Thank you so much, Angie, for coming on today. It was a lot of great information.
All right, we'll schedule another session about something else.
Okay, bye-bye, everybody.
You.
Have a great weekend.
You all too. Bye.
Thank you.
Bye.